You know, usually when we talk about legal rules, there's this expectation of, like, absolute mathematical precision.
Right.
Like, think about property law, right?
Yeah.
You have a fence. It's
Yeah.
either on your land or it's, on your neighbor's land.
Exactly. It's measurable.
Right. If there's a dispute, a surveyor comes out, draws a straight objective line, and a judge just points at the map and says, there it is, you crossed the line, it's clean.
Yeah.
But then you step into the world of criminal law, and specifically the doctrine surrounding rape and sexual assault, and suddenly that mathematical precision it vanishes entirely.
It really does.
Because offense is offense, but human consent, that is a constantly shifting, incredibly murky landscape. Okay, let's unpack this. How does the justice system actually assign liability when two people have, like, wildly different realities the exact same encounter?
I mean, it is arguably the most complex question in criminal jurisprudence. And to understand how the law attempts to solve this, we can't just look at a list of rules. We have to really map out a narrative of how a crime is actually constructed.
Right, from the ground up.
Exactly. So in this deep dive, we are going to trace the anatomy of the offense. We'll start by looking inside the defendant's head, what we call the mens rea, or mental state.
Okay.
And specifically, we'll look at how a mistaken belief in consent just changes everything. From there, we'll move outward to the physical act itself, exploring what the law actually means by force, as well as the insidious roles of fraud and coercion.
Wow. Okay.
And finally, we will examine the victim's reality by tracking how society's definition of consent and incapacity has profoundly evolved.
Which is so important.
It is. Understanding this progression is crucial for you, the listener, because it reveals not just how a courtroom operates, but how our fundamental cultural understanding of bodily autonomy has shifted over centuries.
I think that's the perfect way to approach it. So let's start with that first concept, what's going on in the defendant's head.
Yeah.
The mental state. Historically, I know courts refer to this as a general intent crime. And to a layperson, that sounds like the prosecution only had to prove the defendant intended the physical act of intercourse.
Yes.
Well, what happens if a defendant genuinely but mistakenly believed the victim was actually consenting to the act?
Well, under the traditional historical common law, that mistake didn't matter at all.
Really?
Yeah, it was entirely irrelevant. The traditional approach treated this as a strict liability offense when it came to the issue of consent.
Why?
If you intended to perform the physical act and the jury determined the act was non-consensual, you were guilty. The law didn't care about your internal misunderstanding.
So no excuses.
None. However, the modern legal landscape has fractured completely on how to handle a mistaken belief in consent. We now see a massive division across the country.
How so?
On one side, you have jurisdictions using an objective test, which operates on a standard of negligence.
Okay.
And on the other side, you have jurisdictions using a subjective test, which operates on a standard of recklessness.
Let's ground this in reality because those standards sound very abstract.
Sure.
Let's analyze People v. Mayberry to test the objective rule. First, what are the legally dispositive facts?
Well, in Mayberry, you have this massive collision of stories. The victim testified that the defendant used repeated physical force and horrific threats to compel her to have intercourse.
Right.
But then the defendant takes the stand and paints a totally different picture. He testifies there was no force whatsoever, that the victim voluntarily accompanied him to his apartment and willingly engaged in the act.
Okay, so a total he said, she said, and what was the core legal issue?
The core legal issue the court had to untangle was this. If the governing statute is completely silent on what mental state is required, is a defendant entitled to have the jury instructed on the defense of a mistaken belief in consent?
Okay. What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court established what is now widely known as the Mayberry Rule, which is the gold standard for the objective test.
Right.
The black-letter law states that a defendant is excused from criminal liability if they hold a reasonable and bona fide belief that the victim consented.
Okay. And the elements?
To use this defense, two distinct elements must be met. First, the defendant must possess an actual, honest, subjective belief that consent was given.
Got it.
And second, that internal belief must be objectively reasonable under the surrounding circumstances.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, actual honest belief? I mean, how do you even read a defendant's mind?
You can't, right. So they have to look at actions as a proxy. The sub-issue for this first element is whether this specific defendant genuinely thought she was consenting.
Okay.
The court looked at his narrative, his claim that she voluntarily walked with him through public streets to his apartment without resisting or calling for help.
Right, assuming the jury believes him.
Exactly. The court reasoned that if a jury believed his version of events, they could conclude, as a matter of fact, that he subjectively held a bona fide belief in her consent. So, the first element could theoretically be met.
Understood. Now, what about the second element, objective reasonableness? How do we measure that when the two stories are so wildly contradictory?
That is where the reasonable person standard comes in. The sub-issue here is whether a hypothetical, reasonable person in the defendant's exact shoes could have made the same mistake.
Right.
The court acknowledged the starkly conflicting testimonies. They reasoned that a jury doesn't have to buy one story 100% and reject the other entirely.
Oh, okay.
A jury might believe parts of her story, maybe she was internally terrified and paralyzed, and parts of his story, like maybe she didn't outwardly fight back.
So a mix of both.
Yes. This creates a scenario where her conduct might have been equivocal enough that a reasonable person could have misread the situation. Therefore, the court concluded it was possible for a jury to find the mistake objectively reasonable.
And after analyzing all the elements, what was the court's final conclusion?
The court held that the defendant was entitled to the mistake of fact instruction.
Wow.
Yeah. They looked at the philosophy of criminal law and reasoned that given the incredibly severe penalties and the profound social stigma attached to this specific crime, it's highly unlikely the legislature ever intended to impose strict liability.
That makes sense.
They concluded that punishing someone who lacked a wrongful intent fundamentally violates the principles of justice.
I understand the logic, but let me push back on this with a rather visceral, horrifying hypothetical to really test the limits of these mental state rules.
Okay, let's hear it.
Imagine a defendant engages in rough, aggressive intercourse with a victim. But he does this solely because of a bizarre, gross rumor spread by a malicious third party.
Oh, boy.
Right. Let's say a husband tells a stranger at a bar, hey, my wife actually has this intense fantasy. She likes to be forced and will pretend to resist. She'll fight you, but she really wants it.
Yeah, this is dark.
It is. The stranger goes to the house. The woman fights back, terrified, screaming for him to stop. But the stranger genuinely believes it's all part of a role-play game because of this insane rumor. This actually mirrors the infamous English case, Regina v. Morgan.
It does, perfectly.
How on earth did the different modern standards handle a nightmare scenario like that?
What's fascinating here is how radically different the outcomes are depending on which side of the jurisdictional split you're on.
Okay.
Under the Mayberry objective standard we just discussed, our stranger goes straight to jail.
Good. Why?
Because relying on a bizarre rumor from a random guy at a bar to ignore a woman's actual physical resistance is objectively wildly unreasonable. It fails the second element of the Mayberry test completely.
Right. Which seems like the only sane outcome. But what about the other standard?
Under the Morgan subjective standard, the recklessness standard, the outcome is deeply unsettling.
Whoa.
Yeah. Morgan only asks if the defendant genuinely believed consent existed, regardless of how stupid, irrational, or gullible that belief was.
Wait, seriously?
Yes. If the jury believes our stranger genuinely bought into that absurd barroom rumor, he might completely lack the required mens rea for the crime.
That's insane.
The logic is that criminal liability requires a guilty mind, meaning he had to consciously disregard a known risk of non-consent. If he foolishly thought there was consent, he wasn't reckless, he was just incredibly stupid. And under a purely subjective standard, stupidity is a valid defense.
Wait, so a guy can be objectively totally unreasonable, act on a disgusting rumor, ignore a woman's screams, and walk free because he's just stupid?
Under that standard, yes.
That is wild and terrifyingly subjective. It really highlights how crucial that mental state requirement is. It's the difference between a prison sentence and an acquittal.
Absolutely.
So if the mental state is that messy, let's shift from the mind to the body. I want to look at the physical act itself, the imposition, and the force.
Okay.
The traditional common law has always required the act to be done forcibly, but how much force is actually required?
This is a massive area of doctrinal dispute, representing a tectonic shift in the law. Courts generally divide into two competing standards.
Okay, what's the first one?
First is the traditional extrinsic force standard. This requires proof of force, or a threat of force, that is above and beyond the physical effort inherent in the act of intercourse itself.
So like hitting or pinning someone down.
Exactly. You need something extra hitting, pinning the victim down, using a weapon, choking.
Why did the law historically require that extra force?
Because historically, the legal system was deeply skeptical of victims. The courts wanted undeniable physical proof that a crime had occurred rather than relying on a dispute over words.
Wow, they wanted to see the bruises.
Yes, they wanted broken doors or bruises to prove it wasn't a consensual encounter gone wrong.
Oh,
But the modern alternative is the intrinsic force standard.
and what does that say?
This rule states that the physical effort inherent in the very act of penetration is, by itself, sufficient force if the sexual act is non-consensual.
Let's test this intrinsic force rule because it sounds like a complete redefinition of a word.
It is.
Let's analyze state in interest of MTS. First, what are the legally dispositive facts?
So we have a 15-year-old girl and a 17-year-old boy living in the same house. They had engaged in consensual heavy kissing earlier in the day.
Okay.
Later that night, the girl awoke to find the boy having intercourse with her. She gave no verbal or physical indication of consent prior to the penetration. But importantly, the trial judge explicitly found that the boy used absolutely no unusual or extra force.
Okay, wait. So the judge explicitly said the kid didn't use any extra force.
Mhm.
And what was the core legal issue?
The precise legal question the court had to answer was, can a sexual assault conviction stand when there is no extrinsic physical force used, but merely the physical force inherent in the act of penetration committed without the victim's affirmative permission?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court adopted the intrinsic force rule. The rule they laid out has two clear elements. First, there must be an act of sexual penetration.
Yep.
And second, that penetration must be accomplished without the affirmative and freely given permission of the victim.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step.
Mm.
How did the court apply the first element, the act of penetration? I assume that's straightforward.
Very. The sub-issue was simply whether penetration occurred, which was undisputed by the facts and the defendant's own admission.
Right.
So the court easily concluded the first element was met.
Understood. Now, what about the second element, the absence of affirmative permission? I mean, how does that replace the traditional requirement of violence?
The sub-issue here was whether the girl had granted permission and how the absence of that permission interacts with the statutory requirement of force.
Right, because she was asleep.
Exactly. The court noted that because the victim was asleep or just waking up, she could not and did not affirmatively grant freely given permission. But here is the profound philosophical shift. The court reasoned that in the absence of this explicit permission, the basic, ordinary physical effort required by the defendant to accomplish penetration legally became the requisite force.
And after analyzing all the elements, what was the court's final conclusion?
The court ultimately upheld the juvenile delinquency conviction.
Wow.
They concluded that equating the absence of affirmative permission with the force necessary under the statute was the correct interpretation of the law in a modern society that values bodily autonomy over traditional requirements of violence.
That is a massive shift.
Yeah.
It effectively merges the element of force and the element of non-consent into the exact same thing.
It really does.
Now, what about non-physical imposition? Let's use another hypothetical.
Okay.
Imagine a doctor who lies to a patient. He tells her that an incredibly invasive, grotesque sexual act is actually a highly specialized standard medical procedure to cure a severe chest cold.
Ugh.
Yeah. The patient, trusting the doctor, agrees to the procedure.
This brings us to the fascinating and often disturbing doctrine of fraud. In your hypothetical, where the doctor lies about the very physical nature of the act itself, telling her it's a medical exam when it's actually sexual intercourse that is legally categorized as fraud in the factum.
Okay, fraud in the factum.
Right. The law treats fraud in the factum as legally equivalent to rape. The reasoning is that the victim's consent is completely void because she is entirely deceived about what is actually happening to her body.
So she consented to medicine, but received a sexual violation.
Precisely.
Okay, I want to use an analogy here to make sure I have this straight. So fraud in the factum is like buying what you think is a real car, but you open the garage and it's actually just a cardboard box painted to look like a car.
That's a great way to put it.
You were deceived about the fundamental nature of the object itself. But what if the doctor says, listen, I have a legitimate, real pill that will cure your chest cold, but I will only give it to you if you have sex with me.
Right.
She knows it's sex. To use the analogy, it's getting a real car, but the dealer lied about it having a V8 engine. The object is exactly what you thought it was, but your reason for buying it was manipulated. Does the law treat that the same way?
That is a brilliant analogy. The second scenario you described is called fraud in the inducement.
Okay.
The deception is collateral. As you said, she understands the physical nature of the act, she knows it's sex, but she is deceived or manipulated regarding the reasons for doing it.
Right.
Now, historically, the common law said that fraud in the inducement does not constitute rape.
Why? That seems incredibly manipulative.
It is. But historically, the law applied a sort of caveat emptor buyer beware mentality to human interactions.
Wow.
Yeah, believing that adults are responsible for evaluating the bargains they make, even terrible ones, and the state shouldn't police deceptive seduction.
That's bleak.
However, the law is evolving. Several modern jurisdictions are beginning to change this rule, recognizing that severe abuses of authority, fiduciary duty, or trust that induce sexual acts like a doctor exploiting a sick patient should also be criminalized because the power dynamic destroys any meaningful consent.
So what does this all mean? We've talked about force, we've talked about fraud, but everything we've discussed, force, fraud, mental state, it all pivots on the victim's consent.
Right.
How was a victim traditionally required to physically manifest their non-consent, and how has that specific part of the law evolved over time?
You're right, they are functionally bound together. We can map this doctrinal evolution across 4 distinct stages.
Okay, what's stage 1?
Stage 1 is the traditional utmost resistance rule. Under early common law, the victim was required to demonstrate intense, unabated physical struggle until they were totally physically overcome.
That is awful.
It was. If they stopped fighting out of exhaustion or terror, the law presumed consent.
Wow. And stage 2?
Stage 2 is the intermediate earnest resistance rule, which softened the standard slightly. It recognized that fighting to the death wasn't always possible, but it still required genuine physical pushback to prove non-consent.
And I assume society eventually realized how dangerous that was for victims.
Exactly. Which brings us to stage 3, the modern verbal resistance rule, what we know as the no means no standard.
Right, that's what we usually hear today.
Here, the law finally shifted from requiring physical combat to recognizing communication. A clear verbal refusal is recognized as legally equivalent to physical resistance.
Okay, and the 4th stage?
Finally, stage 4 deals with incapacity. The law conclusively presumes non-consent if the victim is physically helpless, meaning unconscious or asleep, or profoundly mentally incapacitated, which includes profound intoxication.
I can imagine there have been massive foundational policy clashes behind these shifting rules over the decades. I mean, the debates must have been intense.
Absolutely. Objectively speaking, we see 2 major competing policy viewpoints that shaped this history.
Let's hear them.
Traditional law and order groups historically pushed for strict physical resistance requirements. Their argument was that these special evidentiary rules were necessary to prevent false accusations and protect defendants from unfair convictions in ambiguous he said, she said cases.
Okay, I understand that perspective.
Conversely, feminist legal scholars strongly argued that these requirements were uniquely hostile to victims. They pointed out that the law treated victims of sexual assault with a profound systemic skepticism that simply isn't found in other violent crimes.
Right.
To put it simply, we don't demand that a robbery victim fight a mugger tooth and nail to prove their wallet was taken without consent. Why was bodily autonomy treated with less respect than a leather wallet?
That is a staggering double standard when you frame it like that. I think for you listening right now, if you're reading a headline tomorrow about a controversial assault case involving college students or a party, understanding these nuances, especially regarding incapacity, is vital to understanding the world.
Precisely. Understanding the modern boundaries of incapacity is critical for making sense of contemporary legal battles.
Like what?
Take voluntary intoxication. In many jurisdictions today, if a person is impaired through self-administered drugs or alcohol to the point where they cannot appraise their conduct or communicate unwillingness, stepping over that line with them constitutes a strict legal violation.
Wow.
It fundamentally voids any semblance of consent, regardless of the defendant's physical actions, what they believed, or the lack of explicit physical resistance.
All right, we have covered a tremendous amount of ground today. We've gone from the mental state of the defendant to the physical reality of the victim. Can we synthesize all of this?
Sure.
Instead of just an exam diagnostic, I want a mental toolkit. If our listener wants to understand where the legal battle is going to happen in any given case they hear about, what is the checklist?
Here is your mental toolkit for dissecting these incredibly complex cases.
Number 1.
First, look at the actus reus, the physical act. Is the jurisdiction strictly looking at traditional carnal knowledge, or does it encompass modern, gender-neutral statutory definitions?
Okay. Number 2.
Second, evaluate the imposition. Was force used? You have to ask if the court is applying the traditional extrinsic force standard, demanding physical violence, or the modern intrinsic force standard from MTS, where the act itself is the force.
Right.
And if there is no physical violence, diagnose whether there was fraud in the factum, the cardboard boxcar, or an illegitimate coercion.
Got it. Number 3.
Third, assess consent and incapacity. Did the victim manifest non-consent physically or merely verbally? More importantly, was consent legally voided altogether due to incapacity such as age, being asleep, or profound intoxication?
Okay. And the final step?
Finally, check the mens rea, the mental state. If the defendant claims they thought there was consent, apply the specific jurisdiction standard. Is it a strict liability state? Do they apply the Mayberry objective test requiring reasonableness? Or do they use that terrifying Morgan subjective recklessness test?
That toolkit is incredibly illuminating. If you keep those 4 pillars in mind, you can demystify almost any headline or case you encounter.
Before we close, I want to leave you with a final provocative thought to mull over, one that builds directly on these shifting doctrines we've discussed.
Not ready.
If modern statutory reforms continue to push toward requiring explicit, affirmative, verbal consent for every single stage of intimacy, largely to avoid the intrinsic force trap we saw in MTS, how will future courts handle cases where perfectly consensual but entirely nonverbal, spontaneous physical encounters are retroactively scrutinized?
Oh, wow.
Does the law's attempt to completely and perfectly protect bodily autonomy risk inadvertently criminalizing the unspoken, intuitive rituals of human courtship?
That is a profound question, and it brings us right back to where we started. We are trying to build this structure of mathematical precision, this rigid legal architecture of elements and checklists to govern the messiest, most complex, and most emotionally fraught areas of human behavior. It's like the X-ray machine is broken, and we're trying to diagnose the human heart with a legal textbook. It's imperfect, it's constantly evolving, but it's the only system we have. Thanks for taking this deep dive with us today.